In this training module, I'm going to show you a quick reference tool. You can use this reference tool to think about your opportunities to identify and protect your intellectual property. By the end of this training module, you should be able to start thinking about your everyday interaction that might impact or present an opportunity to capture your own intellectual property. Let's get started. You'll see on the screen a worksheet that talks about intellectual property opportunities. This is really just meant to be a keyword list that you can use so as you go throughout your day-to-day life and you start building a business, or you start working with other innovators, or you start interacting with people in technology or other fields, you can think about which words you run across daily that present opportunities to identify and protect intellectual property. Let me say that again. This list is really just a short list of some of the words that you might hear, or you might even say, in your conversations with other people. And when you do say these words or hear these words, I want you to think to yourself, wait a minute, there might be some intellectual property here that I should be protecting. Because a lot of people will go throughout their day-to-day lives, they'll hear all these things, they'll have conversations, and they just don't understand that these are situations where they might have intellectual property. Intellectual property can create value for people, just like the invention you're working on, that will then hopefully be licensed, built, sold, whatever it is that you plan to do to commercialize that and create value for yourself in exchange for placing your innovation out in the public so that other people can have and use it. So just look at this list and think about when you've come across opportunities to hear these words. So just take a look at this list on your own time. I'm not going to read through it. You'll have a handout that you can use and look through differently. Go ahead and add words to it if you think there are others you should have. But I'm going to just talk briefly about 3 different examples from this list. First, I want you to look at the new employee. Anytime you've got an employee coming on board with a company, might be your first employee, might be your only employee, might be your 1,000th employee. In fact, it might even be you. You might be your first employee when you start a new business. Whoever it is, I want you to think about all the different things that are going to happen with that employee. Some employees, they're hired specifically to invent things. That might be you. You're the inventor, starting a company, hiring yourself to invent something. When you do that, there are certain rights that go along with being an employee and certain rights that go along with being the employer. And typically, although it can vary from state to state, the general rule is that employees often are obligated to assign their inventions to their employers. But depending on the state that you live in and the rules that apply, you'll want to double check and make sure that's true. Or you might just want to be cautious either way and put an agreement into place with your employees. The other scenario I want to talk about is listed right below. It's the independent contractor. And I mention this to contrast with the employee scenario. In the employee scenario, employers often will have a right to own the inventions created by their employees within their job description. In contrast, independent contractors are not employed by the employers. They have separate jobs, separate companies, separate titles, and they often, again, depending on the applicable state laws, will be the default owners of the intellectual property they create. So when you go out and you hire somebody as an independent contractor or a 1099 contractor, it doesn't really matter what you call it. When you do that, you'll find that you are placing yourself in a different situation with respect to who owns the intellectual property that might be created in that relationship. I was counseling a client just this morning who had been engaging in some joint venture activities, just some partnership activities with another person outside of her business, and she was wondering what she should do about the content that that other person had been essentially copying from this client. She was taking all of the content and placing it available for the other person to use. Her partner took all that content, placed her own name on it, placed her own copyright information on it, and claimed it essentially as her own. And while that's got its own issues in terms of who owns the intellectual property, it's just as important often to establish upfront the clear communication as to what the expectations are between the parties, especially when you have an independent contractor relationship like a partnership or joint venture. Putting that in place up front gives you the opportunity to make sure there aren't any errors or perhaps any confusion, or maybe feigned confusion sometimes, about who owns the intellectual property. The last one I want to refer to is new improvements. And this is a really kind of vague, ambiguous little phrase that you might hear all the time, but you might say, oh, somebody improved that, or the technology got better, whatever the words are. whenever there's a new improvement, I want you to think about what the improvement is, not just in terms of how it's described to you or how you would describe it to somebody else, but really, what were the details that went into making that new improvement? We often will gloss over those details and just say, oh, I had one of those. They came out with a new version, so I bought it because it was better. Well, what makes it better? What part of the process in using that device makes it more impactful to you as a user? What part of the process in manufacturing that device was more difficult, if at all, because of the new improvement that was included? What part of the technical hardware that was involved had to be modified? Why did it have to be modified? Really get down into a little bit more detail about what a new improvement really means, either for your own inventions or for somebody else's, and start thinking more critically about the fact that an improvement usually is much deeper and more technically involved than simply just making a change. If you're into software programming, you know that one change within a software program could potentially propagate problems throughout the entire program that take a year to go out and fix. Similarly with hardware or with manufacturing processes. Manufacturing processes, as I've walked through different manufacturing plants in the past, are very, very technical. They're very precise. They're very well run. They're optimized for high performance. And if you want to tweak one thing, maybe just even switch the order of two things that are already happening, or you want to add a new step in there, you'll find that it requires many, many, many modifications and lots of money to fix those new problems that come along with the new improvements. And anytime you have new improvements that have to solve new problems, you probably also have the opportunity to identify new inventions. And I want you to be able to understand that process is often how people come up with a portfolio of patents and patent applications to protect their ideas rather than just a single overarching, generally described improvement over something that's already out there. That's it. Now you should be able to think about the opportunities that you might have and the trigger keywords or phrases that you might hear or say throughout your day that will give you time to pause, stop, think about your inventions or your potential inventions and turn those into intellectual property that brings value to you and your company.